You've been severely injured at work in Virginia, and that's hard. But hey, so far, the workers' compensation insurance company's been paying your medical bills, been paying you your weekly checks while your doctor holds you 100% out of work, and as you treat and hopefully start to get better. They even got a nurse case manager involved in your case to help coordinate your treatment. And so now, come to one appointment, and maybe after a little pressure from the nurse case manager, your doctor says, well, at your next visit, we're probably going to release you to light duty, just so you know. And you don't think anything of it. And so next appointment comes, and sure enough, he writes you a work note that releases you to, let's say, no lifting more than 10 pounds, no bending, stooping, crawling, no ladder climbing, something like this. A week goes by, and your check doesn't come. And another week goes by, and your check doesn't come. And you're like, what the heck is going on? And you call the adjuster, and guess what? Crickets. They're not calling you back. So you want to know what the heck happened. Okay, well, there's an explanation for that, and that's what we're going to get into in this video. My name is Joe Miller, workers' compensation attorney in Virginia, North Carolina, and I'm here today to talk about a couple of things. Number one, the importance of light duty, or release to light duty by your doctor, and why that's very significant in your case. And number two, the importance of an award, which I've talked about elsewhere. We're going to get into the relationship between these two things today. Okay, so particularly in Virginia, what you need to know, in a workers' compensation case, there are light years between the concept of being 100% held out of work by your doctor and being put on light duty. Very, very different things, and they make a huge difference in your case. If you are not under an award in Virginia, basically you have no rights. Okay? Now, what you will find is usually, if you have a good case, a compensable claim, the workers' compensation insurance company will pay you benefits, just voluntarily pay you benefits, as long as you're held out 100% from work. Okay? Now, as soon as the doctor releases you from light duty, they're going to cut off your benefits. They're going to stop paying your weekly checks. Okay? Why is that? It's because, as I just said, they're not under any obligation to do anything for you. Why? Because you're not yet under an award. An award is a proclamation by the Virginia Workers' Compensation Commission. That's the governing body over the Workers' Compensation Act in Virginia. And that they say, and they issue a proclamation on a piece of paper that says you are entitled to your benefits, and the Workers' Compensation Insurance Company and the employer must pay you these benefits, at 2/3 of your average weekly wage, okay? And they must do it on an ongoing basis, okay? And you're entitled to a lifetime medical award for your injuries. That's what the award is, and until that is entered by the commission and that proclamation is issued, and 30 days go by, and you have what's called a finalized award, you don't have anything. You don't have any rights at all. Here's what you should do. Okay, let's go through step one. Step one is you call your employer. Okay, and you say, assuming that you still have a job, they haven't fired you yet. Okay, you call your employer and say, look, you got anything for me within these restrictions? You send them your restrictions from your doctor. And you say, y'all have anything for me? I just been released to light duty. Most of the time, you'll find they'll say, no, we don't do light duty over here. Sometimes they'll accommodate you, which is a whole other subject for another video. But most of the time, they won't. So what does that do? That triggers you to go into step two, which is if they won't accommodate you, then you need to do what's called marketing. Okay, marketing your residual capacity to work. It's a fancy way of saying looking for work within your restrictions. Look for and document your attempts to find 7 to 10 jobs per week. That's maybe 1 or 2 jobs a day. So it's not that hard really to do. Sign up for Indeed. Go to the Virginia Employment Commission. Sign up with them. Go look in the newspaper. Make a couple of phone calls here and there. Mix it up a little bit. You can do mostly Indeed if you want to, because it's easy to register with them and it's easy to apply. You want to have a chart where who do you call, when you called, what job you look for, and what should you look for. It should be a job that you can do, meaning that it's within your physical restrictions, number one. Number two, something that you could qualify for. For instance, if you are not an accountant, it will be silly for you to apply for an accounting job, right? So it's going to be something that you could do. Maybe if you're, let's say, a laborer, okay, if you've done manual work, you could probably do like a hotel clerk job with a little training over there. You'll be able to do it. It's within your physical restrictions, and you could conceivably qualify for it with your current level of training or a little bit of on-the-job training, okay? So Again, you need to keep a detailed record of that. So why do you need to do this? Okay, what you're doing is you're creating evidence. Okay, you're creating evidence that you're probably going to have to present to the commission to prove, look, I got released to light duty and I've looked for work within my restrictions and I can't find any. If you've done it adequately and you've done it right, they will grant you your benefits for as long as you have these ongoing job logs. So that's number one. You got to get those job logs done, assuming that your employer won't accommodate you. So after a couple of weeks of doing this and making these job logs, now it's time to file your claim for benefits. Of course, you also want to make sure you get your medical records. You got to get all your medical records and, most importantly, those work notes, or the notes that say you're on light duty, etc. Really, all the work notes you've got from the beginning is what you really want, okay? And so the next step is you're going to file a claim for benefits with the Virginia Workers' Compensation Commission, and you're going to attach all those things that I just mentioned, your medical records, your work notes, and your job logs. You can do that through the Virginia Workers' Compensation web file portal. You can find that online, and they'll give you a PIN where you can do it yourself. You can upload all this stuff. Of course, you're going to have to scan it and all that stuff, but that's something that you can get done if you want to on your own. The employer typically has 30 days now to respond to that, and they're going to do one of three things, okay, in response. They're going to accept it. I'd say if you're on light duty, it's doubtful. They're probably not going to accept it. Number two is they can deny it, which is probably what they're going to do. Or three, which sometimes they also do, they can say, we're just investigating. What's that mean? They're just putting it off. They don't want to respond really, so they're just putting it off. They'll say, we're still investigating it. What you also need to do is get what's called an opinion letter from your doctor. The opinion letter is something that you have to have because you have to prove two things. You have to prove, number one, that your injuries that you suffered were caused by the accident. The medical records typically are not going to be good enough for that. Okay, it's got to be an opinion. It's got to have the magic words. There are certain legal magic words that the doctor has to say. It's more likely than not that your injuries were caused by the accident. And number two, he has to say it's more likely than not that your treatment was medically necessary to help you get better from the accident. Okay, so you've got to have that also. Now, they're going to set a hearing. Also, eventually, it'll be put on the docket, and you'll have a hearing date. And again, you're going to want to keep getting your ongoing medical records. You want to update your work notes and make sure that work note goes all the way through the date of the hearing. Okay, and you want those job logs to keep going, and you want to make sure you have job logs that go all the way through the date of the hearing. You're going to need to produce all that information to the other side. They probably have a lawyer on the other side at least a week before the hearing, probably well before then. And you want to take all that stuff and two extra copies for the commissioner and for the other side before you get to hearing. We're not going to go through the whole hearing process right now, but that's basically what you have to do to get ready for hearing. In Virginia, until you enforce your rights, you don't have any, unfortunately. So these are the things you need to do to enforce your rights. Now, a lot of times what I tell folks is having that award is like having a roof over your case. Until you get that award, you're out in the rain, you're out in the cold. You don't really have any protection. But once you get that award, okay, and the 30 days pass and it's finalized, okay, then you're protected. If we would represent you, what we would do is we would be filing your claim for benefits much earlier. We would not wait till you're released to light duty. We would file them while you're being held completely out of work. And, that's what I recommend that you do. If you have any questions about this, please call us and let us take care of everything for you. If you want to try to do it on your own, that's fine too, but do it early. Don't wait till you get released to light duty. Do it while you're being held completely out of work. It's much more likely in that circumstance, the employer and the insurance carrier is going to agree to accept your claim, and then you'll get under an award that way. Okay, that's called an award agreement, and that means you've won your case, and you don't have to worry about going to hearing. Okay, so that's what you want to do. You want to file it early while you're being held 100% out of work. Okay. Now, unfortunately, you find that insurance companies don't want you to know this stuff, and it's hard to come by this information. And a lot of people scratch their heads and I never heard this before. No, they don't want you to know this stuff. So, if you have any questions about any of this, please don't hesitate to call us. Because even if we don't represent you, I don't want you to make any serious mistakes because we see it all the time. People make big decisions on their case, like quitting their job, or I'm just going to quit because my doctor says I can't do my job, so they quit. Or they get in a situation where they're in vocational rehabilitation and they said, I'm not going to apply for that job, or I'm not going back to work. I don't feel like going back to work, even though the doctor says they can. Okay, so there's a million different ways in those scenarios where you can completely screw up your case and it's almost impossible to reverse the damage. So before you make any big decision in your case, please don't hesitate to call us, okay? Here at Joe Miller Law, the Work Injury Center, we're happy to help you, happy to assist you anytime, okay? Again, I'm Joe Miller, workers' compensation attorney, Virginia, North Carolina. I bless you for a fantastic year, and just hang in there and everybody be safe. Joe Miller out.